Hello everyone, I'm Professor Paul Carrier, Thomas M. Cooley Law School, Western Michigan University. This is part of the midterm review being offered to you by the Black Law Students Association of the Tampa Bay campus. I've already done 2 videos for you to look at, and I want to work on a 3rd video now which covers a few more topics with regard to acceptance. And even though it might not be a significant part of the midterm, I'd like to talk a little bit about consideration, perhaps as a foreshadowing of what you'll need to know by the time we get to the final exam. Last time we talked about acceptance in the last segment of this midterm review. And keep in mind, at the common law, an acceptance had to follow the terms and conditions of the offer quite specifically. If it was required to put it in mail, if it was required to hand deliver the acceptance, that would have to be done. And in fact, the common law, to some degree, still follows the mirror image rule. If you receive an offer and you change something important as an acceptance, that makes yours a counteroffer and a rejection of the original offer. You have flip-flopped who the offeror is. It's now you because you've added a new condition the original offeror did not contemplate. Okay? So the acceptance can be terminated by lapse of time, by rejection counteroffer, or by revocation by the offeror. The offeror could call in time if there's no binding option contract and let you know that your power to accept has been terminated. Death or incapacity as well will terminate the power to accept on the part of the offeree, and that is the death of or incapacity of either the offeror or offeree. If either one dies or becomes incapacitated, the offer is treated as revoked, which, by the way, is different if a contractual relationship has already been formed. Whereas death or incapacity revokes an offer, the power of acceptance basically, the death or incapacity of an offeror or offeree does not change the binding nature of an already formed contract. And if you think about it, you can imagine if someone died and you had a contractual relationship with that person's estate, as it's being wound up after death or even incapacity, can be handled by the administrator of that person's estate. And so though the contractual relationship does not die, whereas an offer, in fact, expires on the death or incapacity of either the offeror or the offeree. A very interesting tool that comes from the Uniform Commercial Code in its Article 2 is Article 2-207, often called the Battle of the Forms. And the idea is this. Often, as between relatively sophisticated business parties, they would send back and forth their different forms with the terms while they're negotiating. Offer comes here and we're going to court if we have a breach. The acceptance, quote-unquote acceptance, comes back and says, agree to everything, but I need a lower price, I need a different color, and it's got to go to arbitration. And then now the offeror, who became the offeree, sends something back. Oh, I can't go with the arbitration, but I can go with the colors and the different price. And so you have this moving back and forth of documents, and you have a battle of the forms. The idea has been the last form to reach one party before acceptance is that final offer. And remember, because the offeror is master of the offer, that would drive or control the relationship. And so parties in some cases would even try to have their form being the last one considered and accepted because it would drive the terms. The UCC in Article 2 tries to avoid that by trying to find a commonality between these dueling forms and form the contract, the intent, the idea, the terms, from everything in those contracts that's agreed. But if there's something different in one of those forms, the UCC now would try to treat that as an acceptance without having it be treated as a rejection counteroffer, and simply then deal separately with those additional or different terms. Basically, under 2-207 sub 1, the subsection 1 of that particular article tries to remove the mirror image rule. It simply says no mirror image rule is required like the common law used to, unless one of the parties to an agreement specifically requires it. And so if people selling goods want that the other party accepts an offer in exactly the format of their particular document. It can be done if it is so specified. If it's not specified, the UCC tries to find an agreement on, that's constituted by everything on which the parties' forms agree, perhaps with a few gap fillers, and then try to address those additional or different terms to see whether or not they do become part of the agreement or they don't. Subsection 2, if you have at least one non-merchant, then a purported acceptance that has an additional term will be an acceptance on those areas where the parties and their documents agree. The additional term, however, is considered a proposal, which proposal does not become part of the bargain if the other party taking a look at it for the first time when he's accepting, if he or she does not specifically agree to it, it does not become part of the contract. It stays a proposal and it drops out. If, however, both parties are merchants, then an additional term, which is different than the last form, will be also treated as a proposal, but here's the difference. As between merchants, that additional term, which is a proposal, will become part of the party's bargain, basically if it's not a big deal. If the other party denies the right to allow additional terms for acceptance, then it doesn't work. If it is a material alteration, if it's a big deal, no warranty, arbitration rather than court cases in case of breach, those are big deals. Those proposals, those additional terms, do not become part of the agreement, even as between merchants, because they're just too much of a big ticket item, and it's presumed that as to those things, the other party would not agree. Also, if there's an additional term and the other party receiving it sees it and provides reasonable notice of its rejection. In other words, he or she writes back and says, no, I agree with all the terms so far, but that additional term is not part of our bargain. We still have an agreement, but without that additional term. And so there is a case that is UCC specific, and it requires, the special rule requires that both sides of the agreement be merchants. So look for that S with regard to merchants on that one. The subsection 3 of 2207, if parties are moving back and forth with agreements, they're still in the negotiating phase, but they begin performance. For example, most of the terms are set, but not all of them, and yet the seller has already put the goods on the shipment and they're halfway across the ocean. We have a significant amount of performance, and to find that no agreement has been reached is simply impractical. It will not work. We must find an agreement, and so subsection 3 to 2207 finds an agreement based on the terms on which the parties agree and based on the facts and circumstances of the performance. If anything is missing, for example, the price, then a court overlooking this transaction could look for a gap filler, some term, reasonable term, to fill in that blank. But the idea being there has been too much performance without full agreement yet to the deal. And yet there's so much performance, a bargain needs to be struck, a bargain needs to be found, and then the details worked out, rather than let the parties walk away, turn the ship around, and pretend as if there's no bargain. So that's 2207 sub 3. In week 4, when we considered the Article 2207 Battle of the Forms, we also considered, particularly with regard to sub 3, the possibility of salvaging deals that are close with its sale of goods, but do not have absolutely all of the important terms. There is this possibility of gap filling or picking default terms. In fact, we learned about a default term with the mailbox rule. What if the offeror asks for acceptance but does not explain how that acceptance is supposed to be effectuated? Then it's reasonable under the circumstances, and by default it is effective on dispatch, not on receipt. Remember, the parties can change that by express language in the contract if they so choose. But as a default, there you have it. Even that's a gap filler. When is a mailed acceptance effective? The contracts don't say. Oh, let's have a default rule. It's going to be when dispatched. That is, in effect, a gap filler. And the Uniform Commercial Code has, in fact, some specific gap fillers that you can find in Article 2, Section 2-305, 304, 305, up through about 2-3 Well, 325, but the primaries go up to about 2-315. Okay, I want to speak briefly about consideration before we finish. However, most of what we need to worry about, particularly with regard to the short answer question on the midterm, has been covered. Let me talk a little bit about consideration before we're done. Remember, I like to treat that as the third main component of formation. You're in contracts 1, formation, offer, acceptance, consideration. Consideration is in significant degree an evidentiary mechanism. How do we know these parties had the current intent to either make the offer or to accept the offer? How do we know that they have skin in the game and they're not lying and holding their fingers behind their backs? Well, consideration is one of the things that shows us that the current intent has been formulated, because it is in Latin a quid pro quo. What someone gives up from his side of the bargain or hers to the other side for his or her return performance. And it could take the shape of a promise. I promise to pay you $1,000 a month for 60 months if you give me title and the keys to your motorcycle. All right? Or if you promise to give me the keys to the motorcycle. If one side makes a promise for the other side's promise to perform, we call that a bilateral contract, and both of those promises are valid consideration because they're enforceable at law. You could have a unilateral contract where you expect performance only. I will sell you the motorcycle when you hand me $10,000. I don't want you to promise. I want cash in hand, possibly a cashier's check. That is a unilateral contract, but your act of giving me the cash, of tendering the payment, would be something that the law recognizes as proper consideration. The forbearance of a right is, in some cases, acceptable consideration. You pay me $5,000 not to do another one of these videos, which I have the absolute right to do. Well, that could be a bargain, and my promise not to exercise a legal right of creating more videos would be proper consideration for your payment. Also, giving up, or the change of a legal relationship. I hit you with my car and your bike. You are not too badly hurt, but you want to sue me for replacement of the bike and some scratches and some pain and suffering. I don't want to go to court. You could take me to court. I could agree to give you $5,000 for your trouble, for your repair of your bike, etc., if you don't take me to court. If you had the legal right to take me to court and you agree to give it up for $5,000, that giving up of the change of legal relationship, the giving up of your legal right to sue me, is in fact also recognized as a valid form of consideration. With regard to consideration, we talked about things that constitute consideration. Those go to the question of sufficiency. The first question with regard to consideration, when you're looking at whether or not it exists and is the appropriate kind to satisfy the requirements, you ask, is it legally sufficient? If I promise my father that I will love and cherish him if he gives me 50% of his estate when he dies, that would not constitute proper consideration because I already have a moral obligation to engage in that behavior. And so his promise to give me half would be one thing, but my promise would be basically ineffective because I'm under a duty or I'm morally obligated to do that anyway. So that would not be treated as legally sufficient. Would a tennis ball be legally sufficient consideration? For the appropriate bargain, the answer is yes. It's a thing. Would the painting of a garage performance be sufficient, legally sufficient consideration? Of course. Again, if there's a correlative balance on the other side. You give me $3,000, I paint your garage. That is a fair exchange, and legally sufficient consideration exists on both sides of the equation. Okay? If you have legal sufficiency of the consideration, courts tend to try not to go into the question of the valuation. It's a qualitative question. But in certain cases, to make sure that we have an actual contractual situation, courts may look into adequacy. For example, if you're worried about a gift, if you're worried about tax evasion, if you're worried about a bribe, all of which could be hidden in the form of a contract, courts will look at the relative values of each side of the consideration to determine whether or not it's adequate. If I give you a tennis ball for $3, that is probably quite fine. It's legally sufficient. No disparate value, no great disparity in the values. What if I give you a tennis ball for your $1 million estate? Something is probably wrong there. The tennis ball is legally sufficient. The $1 million estate is sufficient. But you see that huge disparity. We are probably trying to avoid taxes. We are possibly trying to avoid probate. But something is wrong there. And so there might be a legal sufficiency, but it just doesn't feel right. So the courts will look at the adequacy. And when there is a huge disparity in value, the court will then find that the consideration has not been met. Okay? So, ladies and gentlemen, I hope that you do well on the midterm exam. If you have any questions beforehand, please send me an email through Blackboard or through the Twin page. And I look forward to seeing you in week 6 for the midterm. Thank you.